Good morning, it's Alex Woods here. I'm a civil litigator specialising in the field of financial mis-selling. This is part 3 of the 10 episode series in which I look at the best practice in terms of insolvency practitioners in terms of payment protection insurance following the publication of the guidance note. I'm just going to touch on part 2 to refresh you and to summarise on the asset position. Can PPI be considered to be an asset? I'm then going to move on to this question and whether or not the creditors are entitled to set payment protection insurance claim off to prevent the money being realised. And I'm going to also introduce, and I'm going to go through the guidance notes in that respect. I'm also going to talk to you about the production stats that we've produced so that you have a better idea of the question of to what extent it's worth the candle of instructing third parties or doing it yourself to, whether it's worth realising payment protection insurance in the first place, because there's not much money there, or there's much money there, so I'll come on to that, and then I will conclude. So to start off with, I just wanted to summarise the asset position from the last question and whether or not an asset can be considered to be captured by the IVA. And I had a conversation with an insolvency practitioner at Baker Tilly and an insolvency practitioner, a lawyer at Moonbeaver, who were running an personal insolvency course last week. And she said that whilst everyone was doing bankruptcies, not everyone was doing IVAs. And the reason was because there was some ambiguity around whether or not a payment protection insurance claim could be considered to be an asset of the IVA in the first place. Now, my general view is that a payment protection insurance claim can be captured by an open IVA, certainly is captured in bankruptcy, but I went through a couple of caveats or a couple of technical points. I think the sister I spoke to at Moonbeaver was saying that it was something of an excuse that insolvency practitioners were able to use, perhaps also on top of the fact that it is a headache and it may the cost of processing it may outweigh the value of processing it may outweigh the value of realisations may outweigh the cost of processing. So therefore insolvency petitioners weren't worrying too much about realising payment protection insurance because they had a kind of a get out. I think post the guidance note, that get out is less tenable. Because after all, you do have to contemplate, at the very least do an audit of the asset, and if you're starting to do an audit of the asset, then you will invariably be doing an assessment of its value, and you might as well then go on and process the damn thing. So anyway, I thought that was an interesting postscript really to the last episode. So set off. Right, here are I'm just firstly going to deal with production stats. Here are the production stats on payment protection insurance, and these May production stats disclose that the success rate on payment protection insurance claims is nearly 60%. Set off is around 28-29%. And the average value of payment protection insurance claim, according to our stats, are around £2,300. And coincidentally, I say coincidentally because for a long time now, the industry has been working on a figure of 3.2 payment protection insurance claims per IVA. Coincidentally, that's the figure that we've come up with. There are roughly 3.2 PPI claims per IVA of 2,300 odd value. I think then if you set that in the context of, I mean, these stats, we're not doing currently thousands of IVAs, hundreds. These stats we've been running in 6 months, so these stats aren't gospel. Other people may have other stats. In fact, I know for a fact another company that has been running much larger quantities of IVAs came up with a figure of somewhere around £6,000 per IVA. And apparently that was explained by the fact that they were so big that the banks were going into old loans, PPI on old consolidated loans that had subsequently been refinanced, and perhaps also payment protection insurance claims on credit cards where the insurance had been cancelled years ago, and therefore Data Protection Act requests for the information had only disclosed the most recent open live accounts, or certainly only those payment protection insurance policies that had been in existence for the past 6 years, because banks tend to do the minimum amount of work necessary to satisfy the requirements. Surprise, surprise. So that was how he justified those figures, that they were so big that they had a PPI picker at the bank who actually went in there and was allocated to them, because they were so big, to deal with all their payment protection insurance complaints. I'm not quite sure, that's anecdotal. The other figure that I have is the industry stat that I obtained about 3 years ago, which said 3.2 PPI claims per IVA of around 1,800 value. I would say that at the last law firm I was at, Ferguson Solicitors, we had figures of around sort of 2,500 plus, and we only had one or two PPI claims per IVA. Those stats, it was early days though, so I'm not entirely convinced by those stats. Anyway, I subsequently parted company with Ferguson's in May of last year, and have now been running as a consultant to this law firm in Norwich. And I think those stats are probably more reliable. And now we've had the guidance note, and now we know a little bit more about the banks, the position that banks are taking on set-off. Right, so the conclusion of those production stats for me are that, yes, unfortunately, because I know that most insolvency practitioners see it as a headache. Well, I mean, smaller, medium-sized ones, particularly those companies with smaller numbers of IVAs, to have to do this. But I think that means that you could be looking at potentially, for one IVA debtor, of around £7,000 worth of realisations. Take away 30% for the service company to process that, you're still looking at above £5,000 worth of realisations on an IVA that may be, who knows, let's say it's £30,000 going back to the creditors. It is a bit of an irritating sum, isn't it? 5,000, because it is just sufficiently high. I think that you do have to take it seriously. And at the very least, as I said at my last posting, you kind of really are required with those, sorry for publishing those industry stats, those production stats, because you may be thinking, bloody hell, that means I have actually now got to go to the trouble of instructing a service company to process PPI, or do it yourself. But do an audit. Do an audit. You're entitled to, under the SIPs, to charge for a third party audit. It's not going to be much, 200 quid per IVA. It helps the service company, obviously, to cash flow this stuff. It's not obvious running two businesses that this is actually, going to be hugely profitable for us. And a lot of it has to do with how quickly we process it, how efficiently we process it. I suspect as we reach higher volumes, hopefully it will then be clear that it's going to be profitable. But at the moment, there's some certainty for us, so it is helpful to have our IVAs cash flowed. So you then do the audit, and you then have a better idea of the likely value of the payment protection system in the IVAs. And if you commit to it, I believe you will then, and you find the right company to do it, or you take it seriously in-house, you will, I think, generate bigger returns. I think the principle here is that this is the principle that goes to the payment protection insurance scandal in general, is that it's a case of there's an apple and a lot of claims management companies are just taking one large bite out of it and throwing away the rest. I think, and taking a long time to do it. I think you can actually really eat this apple down to the core, and perhaps the core as well, because of things like refinancing on old payment protection insurance on prior loans that the banks haven't told you about, or payment protection insurance on a credit card over 6 years ago that they haven't told you about. I'm litigating in cases at the moment where on credit cards where the quantum is in our pleadings is over £25,000 on a credit card, consumer credit card. So there's also issues of the quantum, because a lot of the offers that are being made by the banks, I believe, by certain banks, are quite derisory. So there could end up being, if you do take it seriously, there could end up being some genuine profit, dirty word, profit associated with processing the PPI, which, if you're an insolvency practitioner, is very important because it helps oil the wheels of the IVA. Because at the moment it's very difficult to make a living processing IVAs. So, those are production stats and those are my conclusions. So I'm now going to come on to the technical to-do of the guidance note. And what somewhat surprised me about the guidance note was that it vindicated my own convictions about the fact that you can't simply apply the technical letter of the law to this situation. Historically, the IVA has been born out of the Insolvency Act. It's been born out of the rules that relate to someone going insolvent, bankruptcy. Now, therefore, there are and in the R3 2004 terms and conditions, the relevant sections of the Insolvency Act are copied out in terms and just copied and pasted into the standard terms and conditions. So that's the background, and some counsel have pursued, have advised, on more of like bankruptcy orientated advice in relation to PPI within insolvency, within IVAs. Others have taken a view that, well, no, a more equitable approach should be taken to the problem, myself included, and that you shouldn't apply the strict letter of the law in certain circumstances. So I felt myself vindicated because, for me, and this is the headline point really, this guidance note reinforces my belief that the way that an insolvency practitioner should approach the question of PPI within an IVA, an open IVA note, is to make sure that no creditor is preferred. Now, I believe that if you approach PPI, the issue of set-off, respective PPI, with that principle in mind, you can't go far wrong. I'm going to come on to two principal caveats. There's no general rule, but there are principles to use to approach the issue of best practice insofar as financial mis-selling products in IVAs are concerned. Now, why I feel that the practice note, the guidance note, has reinforced my convictions on an equitable approach and not preferring one particular creditor, is that they do major a little on mutuality of dealings, and they say that that is not clear. It is not clear that a payment protection insurance is mutual dealings when taken against a debt. And a barrister whose name I won't mention, because I don't want to make these bulletins too sort of particular, but he is well used by the insolvency sector and has published on it. He had taken a different view, and I'm sure he'd be the first to admit that. and I'm sure he'd also be the first to admit that the whole area is somewhat up for grabs. So, don't forget also that as well as coming to the conclusion of whether or not there has been mutuality of dealings, because if there haven't been mutuality of dealings, then you forget set off, forget the bank trying set off. Aside from mutuality of dealings, there are the issues of whether or not the debt has been the debt has been sold. If it's been sold, forget set off. If it's another legal entity of the same banking group, forget set off. There aren't going to be many situations in which a bank is going to be justified in arguing set off. And I say that ultimately the law is all about, you make the law as you go. The law evolves. The common law, the statute law, English law evolves. And we are evolving the law in this way by producing these sorts of guidance notes. And by people like me posting on video bulletins or writing articles and such like. So now let's assume that you consider that there have been mutuality of dealings. Okay, so the question then becomes, in what circumstances, those two examples I'm about to give, in what circumstances do you think the creditors can be justified in setting off PPI against their own individual debt? Now, I'm not going to go into the number of different potential interpretations that the guidance note lays out on what situation applies in the case of the 2008 Terms and Conditions of the IVA Protocol, because I just think it's too confusing. I think you either take legal advice as it recommends, or you just use your noodle and you apply the principles that I've just enunciated. However, the first exception, as far as the R3 terms of conditions are concerned, I'm afraid you have to accept the fact, in my view, that yes, the origins of the IVA are in a bankruptcy, and yes, if your IVA proposal doesn't say any different, and as often as not, in the case of a 2004 terms and conditions, they won't, then you have to allow the creditor to set off, because in those standard terms and conditions, the provisions relating to self-executing set off will apply. It's automatic and self-executing. Even post-completion, the law will have deemed set off to have occurred before the IVA has commenced, at the time of commencement of the IVA. So where a bank, and Royal Bank of Scotland did this in one of our cases, raises the bugbear of set off in 2004, then I think you'd have to be quite courageous to fight it. You would be fighting it on the basis of the fact that you would be arguing that there was no mutuality. But that's the only would be the only weapon in your armoury. Now, the other area where you might let it go, insofar as the creditor's setting off is concerned, is where there has been a modification. Now, the compliance on call chaps, they come quite a long way down the set off is not allowed route. The polar extreme of counsel I referred to earlier. And they think that even where there's been a modification to the IVA such that set off is allowed, that even in those situations you could argue that point and not allow the creditor to set off. My personal view is, as per the 2004 term conditions, it's kind of tough. One has to accept that the law is the law, that the statute law is the law, and where Parliament has decreed X, you're fighting something of an uphill struggle to conclude Y. So where there's been a modification, or where it's under the 2004 R3 terms and conditions, and of course if the IVA proposal is silent on the matter, which it probably is in most cases, then the creditor is entitled to set off. So, so to conclude, my view is that the set off should be fought, and the general principle should be that no particular creditor should be preferred within the IVA. If you want to get legal on mutuality of dealings and you've got the money to do it, you feel it's sufficiently justified, well, fine, but I think it's going a step beyond your professional obligations, truly, in terms of the time it's going to take you to do that, and the cost and the expense isn't going to be justified by any likely realisation. So that will be an exception. There will be exceptions. For example, I think there'll be an exception where the PPI is so large it might have actually caused the debtor to go into an IVA in the first place. But generally, as I say, where it's under the 2004 terms and conditions and where there's a modification allowing a creditor to set off, you kind of have to let them set off, and you won't be able to realise PPI within the IVA. And don't forget, you aren't allowed to charge where there is set off. And I'm not going to go, there are arguments about that, but I'm not going to go into that. Take it from me, you won't be allowed to charge on a set off. It's not an amount of money that's being introduced into the IVA. It's not cash. Okay, now that's the end of the posting on the issue of set off and whether or not creditor can get away with it. I think the general conclusions are both from the part 2 that I did on whether an asset can be captured by an IVA, and this part 3, whether the creditor can justify set off. The answers are generally resoundingly yes, it is an asset that can be captured. No, the creditor in the majority of cases shouldn't be allowed to set off. Coincidentally, that corresponds with the experience we're getting on the ground in terms of our production stats of what lenders are doing, and we've got lenders to capitulate quite quickly. Remember the 28% figure I gave you earlier about the banks that are deploying set off, and banks are capitulating quite quickly. Not all banks, but some, Co-op for example, where we challenge their set off arguments. So I think the body of what we've got here is leading you in the direction of the best practice is to, at the very least, to an audit, and you probably will have to process the damn stuff too. Now, finally, by way of a coda on this week's video bulletin, I would just like to say that I attended a personal insolvency day of collecting CPD points in an area of which I have a growing interest, and I attended a personal insolvency in respect of both IVAs and CVAs. There were 2 solicitors there and 2 insolvency practitioners there. This is at an R3 event in London on Borough High Street. Very good event. And I made a bit of a nuisance of myself really. I asked far too many questions, and I also spoke to professionals after the event as well. And what was interesting to me is one of the lawyers there was someone who's actually been involved in drafting the guidance note, and he corroborated my general conclusions and feelings about the fact that you take an equitable approach and you don't apply the strict letter of the Insolvency Act backdrop. He also said something interesting was that he's been inundated with insolvency practitioners asking him to process PPI, but he felt that you could do it yourself, that an IP could do it themselves. So I don't think you can rule that out. You might want to do it yourself, and in bankruptcy perhaps it might be easier. So I think generally, and if nothing else came out of that insolvency day, the point that was made by the IVA team in the morning, that was then echoed by the CVA team in the afternoon, was that an IVA is not like a bankruptcy. It is an agreement, between the debtor and their creditors, which you then as an IP preside over and supervise and manage. But it ain't bankruptcy, where you are the trustee and you take a firm grip on things and you realise every asset left, right and centre, etc., and you get stuck in there. An IVA is its own sort of debt tool or debt instrument that is an agreement, and there isn't a lot of statutory underpinning. There's a bit in the Insolvency Act, but there has to be something, but there's not much. So ultimately, I think, once more, that reinforces my conclusion that you take a fair and common sense, and fair, it's in SIP 3 here, a fair approach to dealing with the issue of not just PPI, by the way, but other financial products around the corner like interest rate swaps, when it comes to processing payment protection insurance. And if it helps, you're like the detergent tugs that have been cleaning up the Gulf of Mexico oil spill. That's all for today. Look forward to posting you on episode 4 over the next week or two.